Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos we're talking about humanitarian reinstatements. Now, as I've alluded to in other parts or other videos in this group, prior to what's referred to as Immigration and Nationality Act 204L, a petition could not be reinstated on humanitarian grounds if the petitioner died before the petition was approved. And we're talking now about the I-130. So, it's one thing to, have the I-130 approved and then be waiting, 15, 20 years, 12 years, whatever it is, for the visa number to become current, and during that time the petitioner dies. But it's another thing to actually file the I-130, which that doesn't take that long, 6 months to a year depending, and have the petitioner die before the actual I-130 itself was approved. Well, in Immigration Nationality Act 204L, it's not automatic anymore, and the actual I-130 petition can go forward both to the benefit of the beneficiary and the derivative beneficiaries, which essentially are the children. There's been cases that essentially before this section came out that showed it was improper to automatically revoke the petition. Now, there's a special situation where there's a spouse of an I-130 petition. Now, let's say that there's a widow that had the I-130 filed, and the I-130, before it was approved, the spouse died. In that particular case, the I-130 now will go forward as though it were a special immigrant widow petition, which is generally filed under I-360, in order to allow that widow to be able to become a lawful permanent resident. So it does make a special provision if you happen to be a widow before the I-130 is approved. But either way, make sure that if the petitioner dies, if the I-130 has not been approved, it falls under one section, but if the I-130 was already approved and you're just waiting to consular process, then it falls under another section. But either way, there's help if you get it done right. Okay, more on the coming videos.